Good morning and welcome to today's Kelso Report for Friday, May 25th. I'm your host, Clark Kelso. We start off with a couple of Supreme Court decisions, first involving the Double Jeopardy Clause. Now, the Double Jeopardy Clause protects against being tried twice for the same offense. The clause does not, however, bar a second trial if the first ended in a mistrial. Before the jury concluded its deliberations in Bluford v. Arkansas, it reported that it was unanimous against guilt on charges of capital murder and first-degree murder, and was deadlocked on manslaughter and had not voted yet on negligent homicide. The court sent the jury back to the room to continue to deliberate. The jury did so, but still could not reach a verdict, and the court then declared a mistrial. All agree in the case that the defendant may be retried on charges of manslaughter and negligent homicide. But the question is whether he could also be retried on charges of capital and first-degree murder. Well, the court held 6-3 that the Double Jeopardy Clause did not prevent retrial, since the jury never reached a final decision on capital and first-degree murder, and the court never entered a judgment on those charges. Under Arkansas law, the jury could either convict on one of the offenses or acquit on all. The trial court did not abuse its discretion by refusing to add another option, that of acquitting on some offenses but not on others. The Supreme Court has a dissent in the case. It would have given effect to the announcement in mid-deliberations that the jury was unanimously against guilt on capital murder and first-degree murder, and would have required the court to take some action on what appeared to be a final determination on those charges. In essence, the court could have said, "Jury, is this your final answer?" Next, we have a case involving consumer protection and real estate practices. The Real Estate Settlement Procedures Act provides that, quote, "No person shall give and no person shall accept any portion, split, or percentage of any charge made or received for the rendering of a real estate settlement service other than for services actually performed." The plaintiffs filed suit alleging a violation of this statute because the defendant charged them fees for which allegedly no services were provided in return. The District Court and the Fifth Circuit rejected the complaint, holding that the statute only applies to split fee situations, kickback situations. The Supreme Court unanimously agreed with the lower courts, finding the statutory language to be unambiguous in focusing only on situations where a charge for settlement services was divided between two or more persons. The statute simply does not address the claim that a single entity charged for a service that was not delivered. So the plaintiff's complaint under Section 2607 was properly dismissed. Now we have two habeas cases from the Ninth Circuit. The habeas petitioner in Nitschke v. Belek failed to raise at the state trial court level an Apprendi claim that forms the basis of his challenge to an enhanced sentence under Oregon's dangerous offender law. The Oregon Court of Appeals refused to consider the issue because of the failure to raise it below, and the Federal District Court on habeas held that the claim was procedurally defaulted. The Ninth Circuit agreed. Given the state court proceedings, the only argument for the petitioner was that somehow the state court refusal to consider the Apprendi claim was interwoven with federal law. But that argument failed because the Oregon Appellate Court's decision was clearly based solely on state law and was based on adequate and independent state grounds. Under these circumstances, there's no basis for federal habeas review. Our second habeas case, in Fennenbach v. Director of Corrections, the petitioner argued that his rights were violated when the trial court denied him pretrial access to a minor who witnessed the crime and who refused a request to meet voluntarily with defense counsel. The Federal District Court in the Ninth Circuit agreed that a defendant does not have a federal right of pretrial access to a witness who refuses to meet with defense counsel. The courts also rejected the defendant's argument that the trial court's limitation on the length of cross-examination was unlawful. Defense counsel cross-examined the minor for 3 hours, and the trial court was willing to give counsel an additional 4 hours. For the Ninth Circuit, that was an adequate opportunity for cross-examination, and the petitioner did not adequately explain why he needed an entire additional day for additional cross-examination. Next, an attorney's fees case from the California Court of Appeal. The plaintiff in Frog Creek Partners versus Vance Brown sued the defendant for breach of a residential construction contract. The defendant invoked an arbitration clause but was unable to produce a copy signed by the plaintiff. The trial court denied defendant's arbitration demand, and on a first appeal, the First District affirmed that denial. On remand, the defendant ultimately was able to produce a copy signed by the plaintiff, and the trial court then ordered arbitration. The defendant won in the arbitration on the merits and was awarded compensatory damages plus attorney's fees in the arbitration. Defendant then made a motion to the trial court for pre-arbitration and post-arbitration attorney fees. The trial court gave the defendant the post-arbitration fees plus the pre-arbitration fees for the second motion for arbitration, but also awarded the plaintiff pre-arbitration fees for its initially successful opposition to arbitration. Well, the First District reversed. According to the appellate court, there can only be one prevailing party under Civil Code Section 1717, and the defendant was that prevailing party. So it reversed the award of attorney's fees to the plaintiff and instructed the trial court to consider whether it should award fees, and if so, how much, incurred by the defendant during its initially unsuccessful effort to invoke arbitration. Sometimes even when you lose, you win. According to the rule adopted by the California Supreme Court in Jordache Enterprises versus Brobeck, a cause of action for legal malpractice accrues when the client sustains actual injury and discovers, or reasonably should have discovered, his or her cause of action. In Schifrin versus Spiro, the attorney had drafted a trust document back in 2002 that was intended to ensure that a gift from the husband's mother of real property would be characterized as the husband's separate property. Years later, during marriage dissolution proceedings, the court concluded the trust documents did not terminate and revoke a prior agreement that all property acquired during the marriage would be characterized as community property. A suit for attorney malpractice was filed within 1 year of that determination. But the suit came more than 1 year after the legal challenge to the trust document had been raised and attorney fees were incurred in defense of that trust document. The Second District held in Schifrin that the injury did not occur until the court decided the trust documents failed to make the gift separate property. That expenditure of attorney's fees did not constitute actual injury. And that's it for today's Kelso Report. Have a good long weekend, and I'll see you next Tuesday.